If you have a green card application sitting at USCIS right now, or if you're planning to file one, stop what you're doing and watch this video. In 2026, USCIS has significantly increased the level of scrutiny on I-485 adjustment of status cases. We're talking about longer processing times, more requests for evidence, additional background checks, and, in some cases, interviews that were never required before. This affects hundreds of thousands of applicants across employment-based, family-based, and diversity visa categories. And if you don't know what's coming, you could be caught completely off guard. Stay with me, because in the next 10 minutes I'm going to break down exactly what changed, why it happened, who is most affected, and most importantly, what you need to do right now. Welcome back to Immigration Radar USA, your trusted source for clear, accurate, and up-to-date U.S. immigration news. I'm your host, and today we are covering one of the most important USCIS developments of 2026, the increased scrutiny on Form I-485, also known as the Application to Register Permanent Residence, or more simply, the Green Card application. Now, before we dive in, let me be very clear. Everything in this video is based on official sources. We are drawing from USCIS policy updates, the USCIS policy manual, reporting from the Department of Homeland Security, and verified announcements from the federal government. We will reference these throughout the video. So, what exactly is the I-485? For those who are newer to this process, the I-485 is the form you file when you are already inside the United States and you want to become a lawful permanent resident or get your green card without having to leave the country. This applies to people who are here on work visas, family-sponsored petitions, diversity visas, refugee or asylee status, and other qualifying categories. Millions of people are in this pipeline right now, and in 2026, the rules of the game have changed. Let's get into the details. Starting in early 2026, USCIS began implementing a series of policy and operational changes that have significantly increased the scrutiny applied to I-485 applications. This didn't happen overnight. It is the result of executive directives, updated USCIS internal guidance, and a broader shift in immigration enforcement priorities under the current administration. Let me walk you through the key changes one by one. On screen text, change number 1, expanded background and security checks. Number 1, expanded background and security checks. USCIS has always conducted background checks on I-485 applicants. But in 2026, these checks have been significantly expanded in both scope and depth. Officers are now required to conduct more thorough reviews of an applicant's entire immigration history, going back further than before. This includes reviewing prior visa applications, prior entries and exits from the United States, any prior removal orders or immigration violations, and even social media activity in some cases. The FBI name check and biometric fingerprint process is still part of the system, but now additional interagency checks with agencies like the Department of State, ICE, and the National Counterterrorism Center are being more consistently applied. What does this mean for you? It means your case could be held pending clearance from one of these agencies, and that can add weeks or even months to your processing time. On screen text, change number 2, surge in requests for evidence, RFEs. Number 2, a significant surge in requests for evidence, or RFEs. An RFE is when USCIS sends you a letter asking for more documentation to support your case. In recent months, applicants and immigration attorneys across the country have reported a dramatic increase in RFEs being issued on I-485 cases. And these are not small requests. USCIS is asking for more detailed proof of the bona fide nature of marriage in family-based cases, additional documentation of continuous lawful status, meaning USCIS wants to confirm you have not had any gaps in your visa status, more thorough evidence in employment-based cases, including verification of the job offer and the employer's ability to pay detailed explanations for any foreign travel during the application process, and in some cases, requests for certified translations of foreign documents that were previously accepted without them. If you receive an RFE, you typically have 87 days to respond. And your response must be thorough and complete, because a weak or incomplete response can lead to a denial. On screen text, change number 3, interviews now required for more cases. Number 3, interviews are now being required for more I-485 cases. Historically, USCIS waived the interview requirement for many employment-based green card applications. That policy has shifted. In 2026, USCIS has significantly reduced the categories of cases eligible for interview waivers. More applicants, including those in employment-based categories like EB1, EB2, and EB3, are now being called in for in-person interviews at their local USCIS field offices. For family-based cases, especially marriage-based green cards, interviews have always been common, but now they are being conducted with an even higher level of scrutiny. Officers are asking more detailed and probing questions. Couples are sometimes being interviewed separately, and officers are looking very carefully for any inconsistencies between what the petitioner says and what the applicant says. If you are scheduled for an interview, prepare seriously. Know your case file. Know the details of your relationship or your employment, and bring every document they ask for, organized and clearly labeled. On screen text, change number 4, heightened scrutiny on public charge grounds. Number 4, heightened scrutiny on public charge grounds. The public charge rule has had a complicated history in U.S. immigration. But in 2026, USCIS officers have been directed to apply a more thorough review of whether an applicant is likely to become primarily dependent on the government for support. This means that your Form I-944, the Declaration of Self-Sufficiency, and your Form I-864, the Affidavit of Support, are being reviewed more carefully than before. Officers are looking at income levels, employment history, credit history, use of public benefits, and household size. If there are any weaknesses in the financial documentation, expect an RFE, or potentially a denial based on public charge grounds. This is especially important for family-based applicants whose sponsors are close to the income threshold. Make sure your joint sponsor's documentation is complete and current. On-screen text, change number 5, fraud detection operations intensified. Number 5. USCIS fraud detection and national security operations have been intensified. USCIS has a division called the Fraud Detection and National Security Directorate, or FDNS. In 2026, the resources and authority of this division have been significantly expanded. FDNS officers are now conducting more site visits, showing up at homes and workplaces to verify information provided in immigration applications. This is most common in employment-based cases, where officers may visit the employer's location to confirm that the job offer is real and the work arrangement is legitimate. USCIS is also cross-referencing information from tax records, Social Security databases, and court records to identify inconsistencies in applications. If FDNS identifies a potential issue with your case, it can be referred for a formal fraud investigation, which can result in significant delays, denial, or even referral to federal law enforcement. The message here is simple. Be honest and be thorough in everything you submit to USCIS. Any inconsistency, even one that seems minor, can raise a red flag. Now, let's talk about what all of this actually means for you as an applicant, or as someone planning to file. Impact number 1, longer waiting times. The most immediate impact most applicants are feeling is longer processing times. USCIS processing times for I-485 cases have already been extended across multiple categories. With expanded background checks, more interviews, and increased FDNS activity, cases that might have taken 12 to 18 months are now taking 24 months or longer in some instances. Check the USCIS website regularly for updated processing times for your specific form and your specific USCIS field office or service center. Don't rely on what you heard 6 months ago. The numbers are changing. Impact number 2, more documentation required. You need to think of your I-485 application not as a form you fill out, but as a legal case you are building. In 2026, the bar for documentation has gone up. Before you file, make sure you have a complete and accurate Form I-485 with no blank fields. All required supporting documents, certified, translated, and organized. A detailed personal statement or cover letter explaining your case, proof of continuous lawful status, every visa, every entry stamp, every I-94 record. Complete financial documentation for your sponsor. If you are filing a family-based case, gather extensive evidence of your relationship: photos, joint financial records, lease agreements, communication records, and affidavits from people who know you as a couple. If you are filing an employment-based case, make sure your employer has all their documentation ready: organizational charts, financial statements, and a clearly written job offer letter. Impact. 3. Higher risk of denial. Without proper preparation. This is the hard truth that we need to talk about. The increase in scrutiny means the risk of denial has also increased, particularly for cases that are borderline or cases where the applicant did not respond adequately to an RFE. A denial of your I-485 is not just a setback. It can have serious consequences, including triggering a review of your current immigration status and, in some cases, leading to removal proceedings. This is why many immigration attorneys are strongly advising applicants not to file the I-485 without professional legal help in 2026. The stakes are simply too high. Impact number 4. Travel and work authorization delays. When you file the I-485, you can also file for an employment authorization document, the EAD, and advance parole, which allows you to travel outside the United States while your case is pending. In the past, these combo cards were being processed relatively quickly, sometimes within 3 to 5 months. In 2026, EAD and advance parole processing times have also increased significantly. Some applicants are waiting 6 months, 8 months, or longer. If your EAD expires while you're waiting for a renewal, you could lose your job authorization, which is a critical problem for anyone whose work visa has also expired and who is relying on the EAD to continue working legally. Plan ahead. File your EAD renewal as early as USCIS allows, which is currently up to 180 days before your current EAD expires. Impact number 5. What you should do right now. So, what are the action steps? Step 1. If your case is already pending, check your USCIS online account regularly for any notices, RFEs, or interview appointment letters. Do not miss a deadline. Step 2. If you receive an RFE, do not panic, but act immediately. Consult with an immigration attorney before responding. A strong, well-documented RFE response can make the difference between approval and denial. Step 3. If your interview is scheduled, prepare as if it is the most important meeting of your life. Review your entire application. Know the dates, the facts, and the details. Step 4. If you have not yet filed your I-485, consult a qualified immigration attorney before you do. In the current environment, this is not optional. It is essential. Step 5. Make sure all of your contact information with USCIS is current and up to date. If USCIS sends a notice to an old address and you miss it, your case could be denied for abandonment. Let me bring everything together with a quick summary. In 2026, USCIS has placed I-485 green card applications under a significantly higher level of scrutiny. The main changes include expanded background and security checks that can delay cases, a surge in requests for evidence requiring more thorough documentation, more in-person interviews across both family-based and employment-based categories, tighter review of public charge and financial documentation, and increased fraud detection operations, including site visits and database cross-referencing. The impact of these changes is real: longer wait times, more paperwork, higher denial risk, and delays in work authorization and travel documents. But here is the most important thing I want you to take away from this video. Knowledge is your most powerful tool. If you understand what USCIS is looking for, if you prepare your case carefully, if you respond to every notice on time and with complete documentation, your chances of success remain strong. The system is more demanding in 2026, but a well-prepared applicant with the right documentation and the right guidance can and does get approved. Stay informed, stay prepared. And if you are not sure about any step in your process, talk to a qualified immigration attorney. If you found this video helpful, please give it a thumbs up. It helps more people find this information when they need it most. And if you have a question about your own case or a topic you'd like us to cover, drop it in the comments below. We read every comment and we do our best to help. Thank you for watching Immigration Radar USA. Subscribe for the latest U.S. immigration updates, and we'll see you in the next video.